Imagine this. You are stopped by police in public. Within seconds, they place you in handcuffs and say, "You are under arrest." At that moment, most people panic. They start talking. They start explaining. They start trying to clear things up. But here's the reality. What you do in the first 10 minutes after arrest can determine the entire outcome of your criminal case. One careless statement, one emotional reaction, one attempt to explain yourself without legal advice, and you may hand police the evidence they need to prosecute you. Most people in the UK do not understand what their real legal rights are after arrest, and even fewer understand how police powers actually work under the law. So in this video, I'll explain exactly what you should do if police arrest you in the UK. Not based on myths, not based on social media advice, but based on the actual law. Being arrested does not automatically mean police can do whatever they want. Police powers in the UK are heavily regulated by statute, codes of practice, and human rights principles. An arrest is a formal deprivation of liberty. That means once police arrest you, they are interfering with one of the most fundamental legal rights in a democratic society: your right to liberty. Because of that, the law imposes strict requirements on when police can arrest you, how arrest must be carried out, what information must be given to you, what rights you gain immediately upon detention, how evidence obtained after arrest may later be challenged, and if police breach those rules, the arrest, detention, or evidence may later be challenged in court. The principal legislation governing arrest powers in England and Wales is Police and Criminal Evidence Act 1984, PACE 1984. PACE is supplemented by PACE Code G, governs statutory arrest powers and necessity test. PACE Code C governs detention, treatment, and questioning of suspects in custody. Criminal Justice and Public Order Act 1994 modifies right to silence, adverse inferences. Human Rights Act 1998, Article 5, ECHR, protects liberty and freedom from arbitrary detention. This framework creates the legal architecture for every lawful arrest in the UK. Police need more than suspicion, they need lawful grounds. Under Section 24, PACE, police may arrest without warrant only if 1. They have reasonable grounds to suspect your involvement in an offense, and 2. They reasonably believe arrest is necessary. This is critical. Many people wrongly believe police can arrest merely because they suspect something. Legally, that is incomplete. There must also be a separate necessity justification. The necessity test, PACE Code G, S 24-5. Police must justify why arrest is necessary rather than using a voluntary interview or less intrusive method. Common lawful necessity grounds include to ascertain your true identity, to ascertain your address, to prevent injury to persons, to prevent property damage, to protect vulnerable persons, to prevent disappearance, to allow prompt and effective investigation. If arrest is not genuinely necessary, the arrest may be unlawful, even if police suspected you of an offense. Police must tell you why you are being arrested. Under Section 28, PACE, police must inform you: 1. That you are under arrest, and 2. The legal and factual grounds for arrest, as soon as reasonably practicable. A vague statement such as, "Come with us, we need to ask questions," is not enough. The arresting officer should communicate the suspected offense and reason. Failure to do so can undermine lawfulness. The police caution matters more than most people realize. After arrest or before interview, police usually caution you: you do not have to say anything, but it may harm your defense if you do not mention when questioned something which you later rely on in court. This caution reflects the modern UK position. You have a right to silence, but not an absolute one. Under Section 34 Criminal Justice and Public Order Act 1994, a court may draw adverse inferences where you later rely on a fact in your defense, but failed to mention it when questioned under caution, where it was reasonable to expect you to mention it. This is why the simplistic advice of just stay silent no matter what is legally incomplete and potentially dangerous. Right to free legal advice. Under Section 58. PACE, you have the right to consult a solicitor privately and free of charge while in custody. This is not a favor. It is a statutory right. And crucially, duty solicitors are independent from police. They do not work for the police. right to have someone informed of your arrest. Under Section 56, PACE, you may request that one person be informed of your detention. This is commonly a family member, friend, employer, though delays may occur in limited exceptional circumstances. Right to review of detention. Police cannot hold you indefinitely without oversight. Detention must be reviewed by custody officers, supervisors under PACE time limits. This is designed to prevent arbitrary detention. Right to humane and proper treatment. Under PACE Code C, detainees are entitled to medical treatment if required, adequate food and drink, rest periods, access to toilet washing facilities, religious observance accommodations, protection from oppressive treatment. Police mistreatment can have legal consequences for both evidence admissibility and civil claims. Right to understand the allegation. You are entitled to sufficient information to understand why you are detained, what offense is being investigated, the broad nature of the allegation. This becomes especially important before interview. Let's put this into a real-world example. Suppose police arrest you outside your home on suspicion of assault. You know you are innocent, you are angry, you want to explain immediately. So you start saying, "I didn't do anything, he attacked me first, check the CCTV, this is ridiculous." That reaction is completely natural, but legally it may be one of the worst mistakes you can make. Why? Because everything you say may be recorded in officers' notebooks, may be used in interview, may later appear in evidence, may be interpreted differently than you intended. Even informal comments made in the police van, in the custody suite, while waiting in a cell, during casual conversation with officers can later be used against you. Many suspects wrongly believe it only counts if I say it in interview. That is false. Any relevant statement may become evidence. What to do if your rights are at risk? Step 1. Do not resist physically. Even if you believe the arrest is unlawful, do not physically resist. Resisting arrest can create additional criminal allegations, including assaulting an emergency worker, obstructing police, resisting lawful apprehension. If the arrest is unlawful, that issue is dealt with later through legal challenge, not through force at the scene. Step 2. Ask why you are being arrested. Calmly, ask, what offense am I being arrested for? Police should explain the suspected offense, the factual basis, why arrest is necessary. This helps you understand whether procedure is being followed correctly. Step 3. Say as little as possible. Initially, do not try to talk your way out of arrest. Police often arrest first and investigate further later. Anything you say prematurely may lock you into a version of events, create inconsistencies, be misunderstood, damage later legal advice strategy. Step 4. Request a solicitor. Immediately, the single most important thing to say in custody is, "I want legal advice," before answering any questions. Never assume requesting a solicitor makes you look guilty. Experienced defense lawyers know innocent people need lawyers too. One of the most misunderstood issues in UK criminal law is whether you should answer police questions. There is no universal rule. A blanket, no comment approach is not always correct. Sometimes, full answers help your defense. Prepared statements are appropriate. Selective answering is strategic. No comment interviews are safest. The correct approach depends entirely on evidence disclosed by police, nature of allegation, available defense, risks of inconsistency, adverse inference considerations. This is why interview strategy should be decided with your solicitor, not based on internet myths. If police breach arrest or detention rules, several consequences may follow. Evidence may be excluded. Under Section 78, PACE, courts may exclude prosecution evidence where its admission would adversely affect fairness. Examples include improper questioning, denial of legal advice, oppressive conduct, serious procedural breaches. Arrest, detention may be challenged if arrest lacked lawful grounds or necessity. It may constitute false imprisonment, unlawful arrest, breach of Article 5, ECHR, potentially giving rise to civil claims against police. Complaints, professional misconduct. Police misconduct can be reported through formal complaint mechanisms, though complaint processes are separate from criminal defense strategy. After release, your next steps matter enormously. If released under investigation, bail immediately. Preserve evidence supporting your defense. Secure CCTV quickly before deletion. Identify witnesses. Keep records of police conduct. Follow solicitor advice strictly if charged your case enters the criminal court process. At that stage, you arrest conduct. Interview decisions. Early legal strategy can significantly shape the outcome of prosecution. If police arrest you in the UK, remember these core rules. Stay calm. Do not resist. Ask why you are being arrested. Do not volunteer explanations impulsively. Request a solicitor immediately. Follow legal advice before interview. Preserve evidence after release. Because in criminal law, your first reaction can become your biggest legal advantage or your biggest mistake. If you found this breakdown useful and want practical UK legal guidance explained clearly and professionally, follow and subscribe to BritLaws. We break down real UK laws, real legal rights, and real-world legal situations so you understand the law before you need it. And if you have ever wondered whether police acted unlawfully during your arrest, comment below with your questions for future videos. See you in the next video.